Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I'm your host, Maryann Petri, and there is a non-denominational retreat at the Resolution Center of Jacksonville, Florida. This will be a time of support and renewal for parents and grandparents on the journey of parental alienation, standing strong in resilience, paving the way for good health and a great future. This will take place April 22nd through the 24th of 2022 at the Resolution Center, and I will put all the notes into the podcast notes. And I have a return guest. I'm happy to have Elaine Mickman back on. She was last on November 7th, 2021. She was season 2, episode 125, and she's also been on here prior. Now, she's the author of Courtgate, the court with a dollar sign, divorced from the law, without liberty and justice for all. Now, this book will be on free promotion for this weekend. It's a free ebook for the 19th and the 20th to be found on Amazon. And I welcome you, Elaine, back to the show. Great to have you on.
Hi, Maryann. How you doing?
Okay.
Happy to be back. Thank you for having me. So, some of the new updates or additions. At first, I wanted to tell the folks, try to stay tuned because I am basically saving the best for last.
Awesome.
Okay, so the courts are very, very eroded. I think anyone who's been through the system knows this. And, just in general terms, when I say eroded, they're not ruling by law. They're not compliant with the Constitution. They don't follow legislative laws. They don't even follow their own court rules. And there's just a general lack of integrity. There's bias, prejudice, partiality, and that's mostly likely due to their accepting in-kind gifts and contributions from one party. So one of the new things I wanted to bring up was how the court often violates the Sixth Amendment of the Constitution for different people. And there's also something, a lot of people may have heard of it, but they're not too familiar with it, these IOTA accounts. And there's a little bit of a connection between the Sixth Amendment and IOTA in cases of people that I know. And I'm not sure how much it impacted my case because this only came to my attention recently. So the other main, I'll get to that, but I wanted to just do a general scope of what I'm going to talk about. The other thing I wanted to talk about was due process, how much, we're violated. And a lot of people don't realize how much they're really being violated.
Mm-hmm.
If you were the defendant in a case, due process actually begins with service, being served something. So if you're not served right from the very start, there's due process being violated. Mm-hmm. But if you are, let's say, the plaintiff and you're filing something, due process, it really begins with filing. If you don't have ability to pay the fees, it would begin with, let's say, being denied a fee waiver. They call it informa pauperis. So that right from the beginning, you could be denied from even filing if you don't have the ability to pay legal fees, that they charge. But moving on, if you can afford the filing fee or you're granted that fee waiver, a lot of people don't realize how much power the Prothonotary or the court clerk, it depends, some people have different titles, but Montgomery County, for instance, they call it Prothonotary, and I believe in the Pennsylvania Supreme Court and the Superior Court, they're the appeals courts, they also call Prothonotary, kind of like the filing office. They can actually gatekeep filings. I've even recently had a situation with this. I know other people have had problems. They are basically, the beginning where you file. So if the Prothonotary they can block filings through e-filing. I know people who actually were court ordered where they wouldn't permit them to e-file. I know other people who filed things timely and it was being rejected. So then they sent a hard copy the following day and it was stamped late. So now they're out of court because it's considered late. I had a situation where I sent something in through the mail with a certificate of a proof of mailing, rather. It's a 3817 form at the U.S. Post Office. You pay for that, and the court is supposed to accept your filing based on that date. The rule in the Pennsylvania court is if you need to have some verification for that. I had 3 pieces of verification proof: an envelope stamped with the date, the certificate of mailing stamped with the date, as well as the receipt that matched for it. And they were stamping my filing late, so basically putting me out of court as a result. So a lot of people don't know this. I did research, and I found that even some attorneys who were the losing team were being denied access with the Prothonotary. So, these are really important things to be aware of.
Mm-hmm.
And so the other things that I wanted to bring up with the due process is about best evidence rule. A lot of times they have a double standard in the court. One side is permitted hearsay, then the other side, the other party, the losing side, they require what they call best evidence. You can't just show a document. You need that person to testify in court, the author of a document. And they have this double standard where they let one side get away with, just saying anything they want, which is hearsay, and then the other side hold a different standard. And this really affects the due process rights. So I guess they were some of the things as far as due process. I guess the general things that people know about, not having hearings when you file. They just enter orders denying, dismissing without even giving you a hearing. There's, some general things that people know about, but I just wanted to bring attention to the double standards, the IFP issue, and the Prothonotary. Okay. And the court system, it has really spiraled downward over the years. I think there's always been problems, but it's been excessive. And I think it's really due primarily to the lack of judicial accountability, because we have dysfunctional and ineffective judicial conduct boards, and they're composed of judicial colleagues who pose a conflict of interest. So that would be like sitting judges, other judges, that's their friends and buddies often. Privately practicing attorneys. I think I've mentioned this in the past. I mean, my ex-husband's attorney was the chair of the Judicial Conduct Board when I had a complaint there. Now, how in the world could they possibly look at my complaint when the other side is chair of that board? It's ridiculous. And then they also have politically connected lay people. If you look at those lay people, they're not just, John Doe. They're always someone appointed by the governor or some special means. Now, the other problem, I think, one of the bigger problems I've recognized when you really key in on it, narrow it down, is that our legislators are failing us, because the legislators actually write the laws. They're the ones who are responsible for going in, amending the Constitution, and they're giving the judiciary the green light to run amok, and they're turning a blind eye to the judiciary, superseding and ignoring legislative laws and the Constitution. So the legislators may not have authority with the judiciary violating their own rules, but when they're violating legislative laws, they're turning a blind eye to this. I wanted to also bring to the attention, and with that being said, I would like to say that the judiciary is basically at war with the Constitution and the legislature.
Indeed, I agree.
Yeah, they're just sitting on those benches as if they are a king. They're not they're supposed to be public servants. They're supposed to kind of be a fact finder and just apply the laws and rules that are already in place. And that's not happening. So this is why we're having so many problems with so many cases and so many people. And it impacts with the family court. with guardianships, even probate. These are people's, it's fundamental. It's your private life. It's not just a business deal, and they're destroying lives this way. Well, so I wanted to jump into that Sixth Amendment. So typically when you talk about like Sixth Amendment, most people would think that it's about having a right to an attorney in a criminal case. But with research, I found that there was a case called Lewis, Luis, versus the United States. And this case is from 2016. And they determined that, the court is not supposed to be freezing or withholding a party's own money to prevent them from hiring legal representation. Now, someone I know went through this exact thing. I sort of went through it as well, because when you have marital money as assets and so forth, and one party can access it and the other can't, you're cutting off one party's ability to even use their own money or assets to get legal representation. And then they always seem to come up with, well, whichever side's the controlling party. So in my case, ex-husband, well, like they're going to do me a favor and get permission from my ex-husband. And it always turns out that when there's always some strings attached when the other side is paying, and that's one side controlling the whole case. And this is ridiculous. So, but connected to that, I wanted to bring up something called IOTA accounts. And I don't think too many people really pay attention to this. IOTA is IOLTA, and it stands for, hold on, and I'm bringing this up because a friend of mine just raised this, bringing up all sorts of stuff, and it really connects to that Sixth Amendment as well. So it's called the Interest on Lawyers' Trust Accounts. These are accounts that are set up, and I think you're supposed, now I don't know an excessive amount about it, but they're set up like tax-free accounts. And the big issue is that sorry, I have a train. There's a train going by.
That's okay.
Maryann, so I'm sorry about that background noise there. Okay, these IOTA accounts, they're set up by attorneys, and they're really set up to have an account that is supposed to include small amounts of money for small amounts of time, for things like if a lawyer, maybe they have some filing fee and they keep small amounts in there for different things. But what a lot of times they're doing is using it for some slush fund, and they are running all kinds of money through there, thousands of dollars. So I'm going to just read off this brief thing. Most lawyers must have IOTA accounts in order to hold client funds, because lawyers may not deposit a client's money with their own money. IOTA accounts are interest-bearing checking accounts. The interest on all the IOTA accounts in a state is pooled together and is then supposed to be used to help low-income individuals afford legal help. So when they have your money sitting in IOTA accounts, the lawyer said it's supposed to be building interest that they sort of donate for legal aid. Well, gee, there was millions of dollars, I guess, that were running through these IOTA accounts. And boy, when I needed free legal aid, there's actually Montgomery County is the only county in the state of Pennsylvania that does not even have free legal aid, with the exception of landlord-tenant issues, and that's regardless of their site. Their site might say, oh, we do all these things, custody and stuff. They don't do anything. They do not. If anyone actually calls them up, they'll tell you they do not handle that. They only do landlord-tenant. Okay, so in any event, let me getting back. A lot of times these attorneys, they can, I'm not saying they always do, they can misuse these IOTA accounts as slush funds by textbook and intent. The amount of money for the IOTA account is supposed to be small amount and held in the account for a short time. Therefore, disbursements are tax-free. However, without scrutinizing an account, there's no way of knowing how much money is actually passing through these types of accounts. I happen to know people where attorneys in their cases were receiving payments through IOTA, so the attorneys can potentially receive tax-free payments if nobody's monitoring them to see if they reported the IOTA accounts as reportable income. So, this is something people have to take a look at. Now, when you tie it together with the Sixth Amendment, so this came together when different friends of mine brought up that, number one, there was IOTA accounts, thousands and thousands of dollars being paid through to different attorneys. And then at the same time, these particular people I know were not even allowed to access their own marital monies to get legal assistance for themselves. So I just hope that a lot of, I want to bring attention to people, because these are things that, in hindsight, if you go digging through your records, you might actually find things. And the IRS, boy, they'd be quite interested in this IOTA stuff, because it involves, it is a means for attorneys to be able to launder money and get tax-free money. So you want to take a look at that, and you never know what you'll find. All right, well, I want to move on because we're limited with time. And so I wanted to bring up the issue of judges without subject matter jurisdiction. A lot of times, and it's happened in my case multiple times, these judges basically hijack cases. And why would they do that? Why would anybody want more work than what they already have? So they're judges, let's say, that are not assigned to your case. I'm not referring to an emergency. Sometimes they have to bring a judge in for an emergency. The other judge can't appear. I'm talking about judges when it appears that the other side just went judge shopping to find a judge they have some, the attorneys, let's say, have some relationship to, and all of a sudden, some judge who's not even on your docket continues to show up. And why is that? Why is it that when they complain about judicial economy and they have 2,500 cases on their load for the year, and now they want to take on more cases that they're not even assigned? Well, the point I want to bring up, when a judge is not assigned, or they actually lose immunity, because everyone keeps saying absolute immunity these judges have. Not exactly true. When they don't have subject matter jurisdiction or personal jurisdiction. So personal jurisdiction would be like some judges entering orders for some other jurisdiction. You're a county judge entering orders for out of the country or something of that nature. They do not have the jurisdiction in the area you're in, or they're not assigned. I had a judge in my case. He was rotated out of my case as of the end of 2009, and he shows up and was on the bench all through 2010. And then about 4 months, actually maybe 3 months, in 2011. And the only reason I think he recused was when I filed a Judicial Conduct Board complaint. And I figured, well, he recused because of all those terrible things he did. No, he recused because he was never even the assigned judge for all this time, 15 months. Another judge is on the docket. What is he doing on my case? He doesn't have enough work. I can't remember. He may have either been rotated to civil court or criminal court. As if he didn't have enough work, he keeps showing up. And then even after he officially recused by a court order, for 3-4 months, he starts entering orders. So now those orders by law, by textbook and by law, those orders are supposed to be void and null, and the time doesn't expire. It's not like, well, you got to bring that up in 2 months or 3 months or a year. It doesn't expire if you do the research, but many people don't notice. They live with horrible repercussions. So they're dealing with orders where a judge was not assigned, or they didn't have the jurisdiction. And then on top of that, they enter orders. So those orders are really supposed to be invalid and void. So I know we're almost nearly out of time. It's a shorter podcast. So I'm just going to jump in. What I said, I saved the best for last. Okay, so for all of those who have or are going through court system, an organization, now I'm in Pennsylvania, so for anybody in Pennsylvania, and other states may have similar things, there's this organization called Pennsylvanians for Modern Courts. Now, they sponsored a $5,000 prize essay contest, which is due today.
Oh, I wish I would have known about that.
Wait. Here, think get to the punchline. It's due today, February 18th, 2022, seeking for law students to come up with ideas to use social media to convince the public into having confidence in the judiciary. Well, isn't that interesting? Yeah, I know. Isn't that interesting? They're going to have a law student who most likely had no experience and has no clue. And it's why not ask the public? Why not ask the people who've gone through these? How can we regain your trust? Okay, so based on my experience, this translates into law students being asked to compete in a contest that can use the social media to best deceive and mislead the public to gain public confidence after it was lost as the result of the public's own experiences with the judiciary. And the biggest issue is substituting rule by law with rule by tyranny. So now here's the other thing. Often court systems, they test something to see the results before it expands. So other states may run their own essay contest if and that's if they're not already doing so. There could be other states that have already done this and we're following them. So they're, using these tactics. Now they do have there was a site up where you can just go to probably Pennsylvanians for Modern Courts and I can send it to you.
Okay.
I'll send you just so you can see. Now, so here's what I have to say. We learn what we live. Therefore, if I could have submitted an essay, it would have been titled Top 10 Reasons to Not Have Confidence in the Untrustworthy Judiciary. Number 1, do I have a drum roll? Okay. Judiciary operates Courtgate, where the courts are divorced from the law. I had to put that as number 1. Number 2, the judiciary accepts in-kind gifts with contributions, which promotes case and party bias, prejudice, obstruction of impartiality, all amounting to rigged and case fixing rather than ruling by law. That's not okay. Number 3, the judiciary does not comply with, in fact, they're at war with the Constitution. Number 4, the judiciary does not comply and supersedes legislative laws. Number 5, the judiciary does not comply with nor apply their own adopted rules. Number 6, the judiciary does not comply with the judicial canons. Number 7, the judiciary is typically not held accountable for their misconduct. Number 8, the judiciary talks out of 2 sides of their mouth and does not enforce their own orders, nor do the lower courts comply with appeal court opinions or orders. And of course, they always pick and choose what they're going to enforce. Okay, number 9, the judiciary regularly denies procedural and substantive due process and gatekeeps court access. Number 10, the judiciary is typically oppressive and dehumanizing towards a targeted party. Now, after I wrote that, I thought about a few extras, so I call it the Baker's Dozen supplement. Another 3, the judiciary, number 11, the judiciary has ordered away constitutional rights as a tool to silence a party, censor a case, and cover up fraud and public corruption. In other words, whistleblowing. Number 12, I'm almost there, Maryann.
You're good. You're doing good.
Judiciary in Pennsylvania has a history of ill repute, including the notorious Porngate, Kids for Cash Kitty Prison. Number 13, this actually connects with number 7. There's a non-independent judicial conduct board, which is dysfunctional, ineffective for oversight and discipline, and of public complaints, as evidenced by the 99% dismissal of JCB complaints. But of no surprise, since the JCB is comprised of judicial colleagues, including, I told you, sitting judges, privately practicing attorneys, and politically connected lay people. Now, if all of that is not enough, the PA Supreme Court did not grant permission for allowance of appeal for a Pennsylvania case called Scrip, SCRIP, versus Seneca. And the numbers are 191A3D 917, and the year is 2018. And what that case was is the court quietly ruled the whistleblower law doesn't apply to them. So the judiciary enters an order denying an appeal because they're saying the whistleblower law is not going to apply to them. And what they alleged, that it would undermine the separation of powers. Now, I mean, this is crazy how you can see that they have completely insulated themselves from everything and anything, no matter what. And they have too much power. Nobody's doing anything about it at the legislative, and they have the ability. Anyone can feel free to email me their opinions at courtgate@yahoo.com. That's Courtgate, COURTGATE @yahoo.com. But based on my experience and the experiences of others I know, the judiciary does not have one reason to gain my confidence. Convince me otherwise. And here I'm finishing up, Maryann, because I know we're pressed here for
You're
time.
doing great.
Here's my quote from Elaine Mickman. If eyes are turned blind to the judiciary not ruling by law, then we'll never see justice. You can't get any justice if they're not going to rule by law. And ruling by law includes applying the law to the facts and evidence in your case. That's kind of what the rule of law sums up to.
This was awesome. I learned so much. And okay, so is there anything else you'd like to add?
That's kind of it. You know, I could have gone for, more detailed, but I know
we will, because I'm going to have you back on.
Yeah, pressed for time here, but yeah, and I'm happy to be on and give any of my information, perspective, and anybody again is free to share their opinion with me. Anyone share to they're free to dispute anything here, but I
don't think there's anything to dispute.
Yeah, well. But anyway, I will also email you over that contest, which is really something there, that they're going to ask somebody who has nothing to do with it. Go ask the people who don't have the confidence in the court system. They're the people who will give you the information they're looking for.
So is it possible, can I write in today and write them a paragraph?
Go right on ahead. I'm going to email you, and right after we finish up, I'm going to I will email you over a picture of the or the link, and you'll take a look at it. Go right on ahead. That would be awesome.
And I encourage others to do this even after the date. Why not just send in your stories even after this contest is over?
Yeah. Okay.
But hey, Elaine, don't jump off, okay?
Yeah.
Slam the Gavel is a podcast to help the public understand what really goes on in these family courtrooms that in turn perpetuate parental alienation. I'm your host, Maryann Petri, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, and Cry Out for Justice, Poems of Truth. Please join us again here with Elaine Mickman in the future and other exciting guests. Thank you again, Elaine. Thank you so much for your knowledge.
Thank you. All right. Bye-bye.